An argument from a traditional constitutional perspective against birthright citizenship in the United States focuses on the original intent of the Constitution's framers and the historical context of the 14th Amendment. The framers of the Constitution did not intend for all children born on U.S. soil to automatically be granted citizenship. The primary concern was the issue of allegiance. The original understanding of citizenship was tied to the idea of allegiance to the nation and the legal framework of the time, which emphasized a connection to the country through either birth to citizen parents or through naturalization. The text of the 14th Amendment says, "All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States, and of the state wherein they reside." The clause's emphasis on subject to the jurisdiction thereof means that children born to foreign nationals, especially those in the country unlawfully, should not be considered subject to U.S. jurisdiction in the same way as children born to citizens. The phrase, "subject to the jurisdiction thereof," was historically understood to refer to individuals who were politically and legally subject to U.S. laws, including military obligations, and were not under the control of a foreign power. Thus, those born to foreign nationals in the U.S. are not subject to U.S. jurisdiction in the same full sense. The 14th Amendment was primarily intended to grant citizenship to former slaves and their descendants following the Civil War. It was not designed to address the issue of children born to non-citizens or to foreigners residing temporarily in the U.S. In fact, the framers of the amendment were concerned about ensuring citizenship for freed slaves, but they never intended to create automatic citizenship for children born to foreign nationals or those living in the country without legal status. From this perspective, a broader reading of the 14th Amendment, which grants automatic citizenship to anyone born on U.S. soil, goes beyond the original intent of the amendment's drafters. The policy should be interpreted more narrowly in light of the nation's evolving relationship with immigration and the unique circumstances of its time. While the Supreme Court has upheld birthright citizenship through cases such as United States v. Wong Kim Ark in 1898, this ruling misinterpreted the original constitutional intent, and the issue should be revisited in light of changing societal conditions and the nation's modern understanding of citizenship. In summary, from a traditional constitutional perspective, the argument against birthright citizenship focuses on the belief that the 14th Amendment's citizenship clause was designed for a different context, one that was more concerned with citizenship for formerly enslaved people and those under the full jurisdiction of the U.S. legal system, and extending this to children born to foreign nationals in the country unlawfully is a misapplication of the original text.